Got a few hands, a few strays here.
All right. Yeah, I saw you in the gallery, Bolton. He's not lying. I saw you there. Okay. Thank you. But I hope everyone got a good night's sleep. And let's talk about
And
yesterday.
if not, there's
And
always coffee.
as everyone knows, the Senate had a long but crucial debate over the rules of the trial last night, and it lasted into the early hours of the morning. Now, the American people expect a fair trial. Our oaths, our solemn oaths to the impeachment trial and to our Senate office demand it. So before we proceeded to opening arguments, it was non-negotiable for us that the Senate at least consider the question of evidence, witnesses, and documents, and the rules of a fair trial. I publicly offered to delay some of the votes until today to spare everyone from staying late. But Leader McConnell was so unwilling to let the trial of President Trump go on for one session longer than he had planned, he declined to delay any votes. It seems the only reason Senator McConnell refused to move votes back a day is because it would interfere with the timeline he promised the president. Not what's a fair trial, not what's letting the American people hear what they have to hear, but just what President Trump, the defendant here, wanted. Now, if there's one thing we learned from the series of votes on the Senate floor, it's that Leader McConnell and Senate Republicans don't want a fair trial that considers all the evidence. On 4 separate votes, every Senate Republican voted against requesting relevant documents for the trial. On 3 other votes, every Senate Republican voted against calling relevant witnesses before the Senate. Republican senators even voted against amendments that made basic, fair, procedural fixes. One that prohibited the White House from selectively leaking documents, and another giving both parties a reasonable time to respond to motions. Even those they opposed. At the very end of the night, every Senate Republican rejected Senator Van Hollen's amendment to place the question of witness relevancy in the hands of the Chief Justice, and voted down an amendment to guarantee the consideration of witnesses and documents later in the trial. That particular amendment, the one that would guarantee votes on witnesses and documents, revealed the charade that the Republicans are participating in here. All along, Republicans have said it's not that we don't want witnesses and documents, we just want to vote on them later. We explained why that made no sense from a trial perspective. It meant that presentations could not rely on this important evidence, that senators cannot ask questions about this evidence, and can only decide on this crucial question once the trial is basically over. We've been calling it Alice in Wonderland trial. But even then, Leader McConnell's resolution allows only one vote on whether motions to subpoena witnesses and documents are in order. He amended it, different from the Clinton situation, the Clinton impeachment. Only one vote on whether to have witnesses and documents, not a vote on witnesses and documents, merely a vote on whether to have a debate about having a vote on witnesses and documents. When we offered an amendment to actually guarantee votes on witnesses and documents after the question period, after the presentations, instead of one vague procedural motion, every single Republican said no. So when they say, oh, they want to make sure we'll vote on witnesses and documents later, their votes belie that. The bottom line is this. The very first thing the American people saw when they tuned into the impeachment trial of President Trump was Republican senators voting against having a fair trial with relevant evidence. It's clear that the American people overwhelmingly support a fair trial and overwhelmingly support witnesses and documents. So, it was a dark day and a dark night for the Senate. As a consequence, the impeachment trial of President Trump begins with a cloud hanging over it, a cloud of unfairness. Democrats will seek additional votes on witnesses and documents down the line. Yesterday, we put the spotlight, Yesterday, we put the spotlight on the number one issue in having a fair trial, witnesses and documents. That's just where the spotlight belonged. And I predict that as a result, that spotlight will continue to focus on witnesses and documents, and the pressure will continue to build on Republican senators. As we saw yesterday, Leader McConnell was forced to tweak his organizing resolution before it was even offered, with modifications scrawled in the margins, after several Senate Republicans agreed with Democratic objections. I'm glad a few of Leader McConnell's most egregious proposals were expunged, but let me point out, the fact that McConnell had to change his resolution showed that Republicans can make this trial more fair if they want to. It's not a question of ability. They can, if they want. It's a question of conscience. Senate Republicans have the power in their hands to make it a fair trial. Will they use it when it matters? The next real test will come after Q&A, when we revisit the issue of witnesses and documents. I want to make one final point. The House managers made a very clear and compelling case, not only on the glaring need for evidence, but also on the gravity of the president's offenses. In stark contrast, the White House defense were unprepared, confused, and totally unconvincing. White House counsel resorted to the kind of histrionics you see on Fox News evening broadcasts, rather than any sober-minded argument that could persuade thoughtful senators. On multiple occasions, they made discrete and demonstrable factual errors. The president is always loose with the truth, and it seems his lawyers are the same way. Most telling of all, White House counsel were far more preoccupied with making inflammatory and inaccurate statements about House managers than providing an actual defense of the president's conduct. This does not bode well for the president's case if this pattern continues over the course of the trial. Senator Murray.
Well, thank you, Senator Schumer. Look, the difference between what we saw from Senate Republicans and Democrats last night couldn't have been more stark. Democrats made very simple, straightforward requests for documents and testimony directly related to the charges against the president, information that so far has been hidden from the public. And each time, this Republican-controlled Senate said no. They said no to allowing the president's key aides to testify, no to allowing documents that could shed light on the president's actions to be subpoenaed. They said no to each and every attempt on our part to ensure a fair and honest trial. Look, if the president is truly as innocent as he claims, Republicans should want his aides to testify. He should want his administration's documents to be considered. Clearly, they don't. The charges brought against this president that he demanded a foreign government interfere in our elections to help his campaign, that he abused his power as president and obstructed Congress, could not be more serious. This is about our democracy and our future, and we are going to keep doing everything we can to push for a fair and honest trial like Americans deserve, not a cover-up.
Senator Whitehouse.
Thank you, Chuck. Good morning. It is clear from last night that we are now on a partisan forced march towards a predetermined outcome. I fully agree with Leader Schumer's remarks in that respect. I want to add an additional point. I have been an assistant attorney general and an attorney general in my state. I've been a United States attorney. I've been the governor's legal counsel. I've been a practicing private lawyer. I have taught in law schools. For 40 years, I have looked at, participated in, and studied legal proceedings. And one thing is true, whether you're looking at a criminal proceeding or a civil proceeding or an administrative proceeding, and that is that there is only two ways in which evidence is kept out of the proceeding. One is if it is excluded because of some legal bar to its presentation, and the other is if you don't know it's there. There is no third way. This proceeding, in my reckoning, for the first time in a multi-century tradition of American legal history, is denying to a legal proceeding evidence that we all know is there, that the House managers actually said is sitting in boxes ready to be produced to the Senate, without any finding that any of it should be excluded. Indeed, there could be no finding that it should be excluded because it meets every standard for the presentation of evidence. So my point for those who are not as familiar with the background to where we are right now as they might be, is what a bizarre aberration this proceeding has become against a long and otherwise uncheckered background of American legal tradition. It is, as Leader Schumer said, a dark day from a dark night. Thank you. Senator Murphy of Connecticut.
Thank you very much, Senator Schumer, Senator Whitehouse, Senator Murray. This trial thus far could not be further from historical precedent. This is the first time in history that a president has refused any and all cooperation with an impeachment inquiry, no documents, no production of witnesses. This is the first time that the Senate has adopted rules designed to present evidence from being entered into the record. This is the highest bar ever created in order to produce witnesses before a Senate trial. The goal is simple: to speed through this trial as quickly as possible, with as many hours of testimony being in the middle of the night as possible, to acquit the president as quickly as possible. We see our responsibility as truth finders, as fact seekers, and you cannot get to the truth of this matter without having witnesses and without having evidence. As Senator Schumer pointed out, something interesting happened yesterday. After Leader McConnell released his first version of the rules, which shocked everyone as it was going to force the House managers to present much of their evidence in the dead of the night, those rules changed. They changed because Republican senators pressured Leader McConnell to do it. You know why? Because they know that the American public is plugged in. They know that the American public is not going to stand for a rigged trial. Now, they didn't unrig the trial with these small, last-minute, handwritten additions. But what we did see yesterday is that Republicans understand that their constituents are paying attention. And if they continue to obstruct the journey for truth, if they don't allow for any document protection or any witnesses, there is going to be hell to pay back in each one of their states. Ultimately, the people are in charge. And I think the people want us to continue to fight to make sure that this is a fair trial and all the facts are in front of us, no matter how senators may vote in the end.
Questions? Yes.
On the question of witnesses, are you willing to let Republicans bring in former Vice President Joe Biden or his son Hunter to testify in order to get the witnesses that you want?
Look, the bottom line is that the witnesses should have something to do with and direct knowledge of the charges against the president. You know, we don't need to have witnesses that have nothing to do with this, that are trying to distract Americans from the truth.
But if it comes
Yes.
to that,
No.
would you cut a deal of any kind with Republicans to ensure that Americans get?
Well, right now, we haven't heard them wanting any witnesses at all. So our first quest is to continue to focus our efforts and focus the American people on the need for a fair trial, which means witnesses and documents that, again, reflect the truth. And the bottom line is this. We don't know what these witnesses and documents will reveal. They could be exculpatory of the president. They could be incriminating of the president. These are certainly not Democratic witnesses or Democratic documents. We want, as both of my colleagues said, the truth, and that's what we're going to focus on. Yes?
You said there would be additional motions down the road. Can you expand on that?
Well, the motions now will be made. Right now, we will have the arguments by the House managers, then the arguments by the president's lawyers, then there'll be a question period. We will certainly try to find ways, whether it's the House managers, who I imagine would want to do it themselves, or us, to get direct votes on each witness and document once again after the arguments are made. Yes?
During yesterday's long session on the floor, did you speak with McConnell at all to try to put together a deal, maybe to go into closed session, or to come up with a deal on evidence and witnesses or votes or procedure? Were there any negotiations?
Well, the one negotiation was sort of done in public, where Leader McConnell wanted to stack votes. We said no, but we didn't want to go late into the night. That was McConnell's choice. And it seems, both by his initial offer in terms of the resolution and what happened, they want it in the dark of night. They want as much of this hidden from the American people as possible. But the good news is, as Chris mentioned, Sheldon and Patty, the American people are focusing on this. And Republican senators realize that. And our hope is they will go to Leader McConnell and say, your obeisance to do whatever Trump wants is not serving anybody very well, certainly not the American people. Yes?
Do you think Leader McConnell was genuine in making those last-minute changes, or do you think he had those in his back pocket?
I don't know. I was not there, so I wouldn't speculate on that. I get a sense from what I heard reports at the Republican lunch that a large number of Republicans thought it was egregiously unfair. It's still unfair. And we hope that it's sort of a prelude to putting pressure on McConnell for real votes and getting witnesses and documents that the witnesses and documents that we've asked for. And if they have other suggestions about witnesses and documents that have direct effect on the trial and have knowledge of what happened when the aid was cut off, we're open to hearing about it. Yes?
How much coordination are you having with the House managers as they present their case?
Not very much. Now, we are not like McConnell. We're not secretive and close to the vest. 3 weeks ago, I sent a letter to McConnell and to every member of the caucus saying we wanted votes on these seven. We wanted these 7 votes. It was 4 on witnesses, 3 on documents. We ended up putting 2 together because they were related, Duffy and Blair. And then yesterday I said I said publicly, we are going to try and undo some of the most egregious parts of McConnell's deviation from the Clinton plan. Most particularly, we wanted to undo the situation where there would not be an ability to ask for votes on the witnesses and documents afterwards. So they sort of know what we're doing, and we are not taking our signals from them. We decided in a caucus ourselves what amendments we wanted to ask for yesterday. Yes?
Do you worry at all that the strategy to push for witnesses and documents, including the late-night vote last night, will turn off some of the moderate Republicans that you guys will need to follow through on this?
Look, here's the bottom line. We're seeking the truth. The American people want the truth. We would be derelict in our responsibilities if we didn't ask for these votes. Remember, this is the only time we're guaranteed getting a vote on witnesses and documents. And so we would not be doing our job if we didn't try to make this trial fair. We're going to continue to do it. And what will determine, in my judgment, how people vote is their conscience and their knowledge that the American people realize we're right. Yes?
Are you concerned that the managers were too partisan, like Rep. Nadler saying that the GOP was involved in a cover-up, and do you think it's hurting?
You know, what I said here, I believe, that the arguments of the House managers were overwhelmingly on the merits, on the facts. The arguments of the president's lawyers were like a Fox News show, a lot of finger-pointing and nothing to do with the actual facts. I thought about this as I was listening. If this was an actual trial and you were a jury, after those arguments, I'd be certain that the president's managers would prevail and the president would be convicted. because when you sit in a jury box, you're hearing the actual facts. And all these things, oh, this, that, and the other thing that have nothing to do with it, which it seems to be the president's lawyer's way of arguing, don't really make a difference. Any seasoned lawyer, Sheldon's not here. You're not a seasoned lawyer. I'm not a seasoned lawyer. You're not a seasoned lawyer. But any
Preschool teacher, though, and I can tell you.
yeah,
I will.
same thing. So any jury sitting there would have been overwhelmed by the huge and important and really factual, direct discussion of what happened. So I think, and one other point. This may be the first time many of our Republican colleagues are actually hearing the arguments made by the House. When you have to sit there, no iPhones, no laptops, no phone calls. It's a different way to approach it. So, I think it's successful. And I think the next 3 days, I'm really looking forward to hearing the House manager's case go to the senators sitting there without their phones and laptops, and to the American people. I think it's going to be very, very powerful. I read their brief. It's great. Thank you, everybody.